Honorable Mr. Justice Dinesh Maheshwari, Judge Supreme Court of India. Honorable Mr. Justice Indrajit Mahanti, Chief Justice and Patron Chief, Rajasthan State Legal Services Authority. My sister and brother judges of Rajasthan High Court. Brother Justice Vijay Bishnoi, Judge in Charge, Mediation Center, Rajasthan High Court. Mr. Brajendra Jain, Member Secretary, RSLSA. Ms. Poonam Dargan, Director, RSLSA. Chairpersons and Secretaries, District Legal Services Authorities of the State of Rajasthan. Officers of the RSLSA. Dear Judicial Officers, Trainee Judicial Officers, Mediators, ladies and gentlemen. I heartily welcome all of you on behalf of RSLSA to this webinar on the strengthening justice delivery system, synergy of adjudicatory and ADR processes. We are deeply obliged and greatly honored by the presence of Hon'ble Mr. Justice Dinesh Maheshwari, Judge Supreme Court of India, with the splendid qualities of head and heart, His Lordship's command, reverence from one and all. We had the privilege of seeing him as an eminent lawyer, a great judge, caring elder brother and guide. Sir, we are grateful to you for accepting our invitation to deliver the keynote address in this webinar. On behalf of RSLSA, I extend my cordial and affectionate welcome to your Lordship.
Thank you. Thank you.
We welcome Honorable Mr. Justice Indrajit Mahanti, the Chief Justice, Rajasthan High Court and Patron Chief, RSLSA, who has most graciously consented to attend this webinar. We also gratefully acknowledge the presence of sister and brother judges of Rajasthan High Court. Friends, the concerns about slow pace, high cost, procedural complexity, and lack of predictable outcomes associated with the litigation have been raised repeatedly. The picture of litigation that emerges might confirm the long-standing criticism that justice delivery system takes too long and costs too much. But the courts do not possess magic wand which can wave to wipe off the huge tendency of the cases, nor can they afford to ignore the instances of injustices and illegalities only because the huge errors and delay in disposal of the cases. If courts start doing that, it would be endangering credibility of the courts and may erode the tremendous confidence they still enjoy from the common man. To deal with such a situation, alternative dispute resolution can be a helpful mechanism which strengthens judicial modernization, unclogs the courts, increases access to justice, reduces cost, and saves time. The need to evolve alternative mechanism to reduce the burden of the courts and provide species access to justice along with revival and strengthening the traditional system of dispute resolution prompted the introduction of Section 19 in the Code of Civil Procedure 1908. Section 89 of the Civil Procedure Code provides the opportunity of alternative dispute resolution to the pupil in the form of arbitration, conciliation, mediation, and lok adalat. Out of these ADR tools, mediation is a process to resolve a dispute between two or more parties in the presence of a mutually accepted third party who, through confidential discussion, attempts to help the parties in reaching a commonly agreed solution to their problems. The biggest advantage of mediation is that the entire process is strictly confidential. Mediation saves time and the financial and emotional cost of resolving a dispute, thereby re-establishing trust and respect amongst the parties. A properly conceived mediation as a method of alternative dispute resolution will ensure wide access to justice for all sections of people. There are 169 mediation centers across the Rajasthan where 1,027 trained mediators are providing their services. The ratio of settlement of dispute through mediation in the state in preceding 3-4 years is more than 20% of the refer cases. The evolution of Lok Adalats as yet another tool of ADR was a part of a strategy to relieve heavy burden on courts, and the same have now assumed statutory recognition under the Legal Services Authority Act 1987. For more than 3 decades now, NALSA and state legal services authorities have been working towards the noble goal of providing legal aid and services to the weaker section of the society. And the Lok Adalat are being organized under the aegis of NALSA and the legal services authorities on regular basis. Last year, in the month of August, NALSA, under the aegis of NALSA, conducted its first ever online Lok Adalat in the state of Rajasthan amid the restricted judicial functioning owing to COVID-19 outbreak, and the same was a giant leap in introduction of technology in the domain of dispute resolution. It was organized all over the state of Rajasthan, where thousands of legal disputes were taken up for resolution, out of which 30,546 were settled, which include 29,092 cases pending in the courts and 4,384 pre-litigation cases. The first National Lok Adalat, organized by RSLSA this year on 9 July, was also a huge success, wherein total 279,979 cases were taken up, out of which 76,138 cases were settled, which include 63,438 pending cases and 12,700 pre-litigation cases. The ADR movement needs to be carried forward with greater speed. This will considerably reduce the load on the courts, apart from providing conclusive justice without substantial costs being involved. If they are successfully given effect to, the goal of rendering social justice to the parties to the dispute shall be achieved in more realistic manner. I am sure this webinar organized by RSLSA will definitely help to develop meaningful communication on relevant issues amongst the stakeholders and will help remove stumbling blocks, which include static mindset of people, lack of positive approach, and general apathy to try out ADR as an effective alternative to conventional dispute resolution mechanism, and lack of awareness regarding enforceability and finality of resolution arrived at through ADR. Once again, I express my gratitude to Hon'ble Mr. Justice Dinesh Maheshwari for his lordship's continued support and encouragement to Team RSLSA in its endeavor to achieve its motto, access to justice to all. Thank you all.
Thank you, sir. Now I request Honorable Mr. Justice Vijay Bishnoi Chairperson, Rajasthan High Court Mediation Cell, Jodhpur, for his Lordship's introductory address. Honorable Mr. Justice Vijay Bishnoi sir.
Honorable Mr. Justice Dinesh Maheshwari ji, Judge Supreme Court of India, Chief Guest and Keynote Speaker on today's webinar. Honorable the Chief Justice Indrajit Mahanti ji, Honorable Justice Sangeet ji Lodha, Executive Chairman Rajasthan State Legal Services Authority, my brother, judges and sister judges of Rajasthan High Court, Excellencies in the meeting, esteemed guests and dearest participants. Greetings to all. A few days back, I learned after all this time of ragging pandemic and successive lockdowns, the pendency of the cases in courts have risen by 19% since last year. This is when the courts have been taking up urgent cases only. Adding on further, there would be an n number of disputes which haven't even been reported because of the COVID protocols and traveling restrictions. This shows a worrisome picture of judicial justice delivery system in India. Let alone the pandemic, even in the times of normalcy, the pendency have been an agenda haunting the minds of adjudicators and jurists. The pending cases stood at 3.68 crore in March 2020, after which the situation have gone downhill. The prime concern here stands to be a better justice delivery. Judicial process in India itself is a little complex, so much so that general public fears the complexities, the advocate fees, the long years of pendency, more than they fear the decree or a sentence. That the procedure cannot be done away with, since they in a way signifies the rectitude of judicial process. In order to make the justice delivery more efficient and to accelerate the process, the law courts, in conjunction with the alternative dispute redressal techniques, might serve the purpose. This thought must be discussed and developed to a well-suited solution. Hence, the topic of today's webinar is strengthening justice delivery system, synergy of adjudicatory and ADR process. This is not the first time the problem is being discussed. A few days back, Honorable Chief Justice of India, Justice N.V. Ramanna, discussed about the need to have mediation as a mandatory first step for resolution of a dispute. He went on to suggest that a new law might be needed to fulfill the vacuum. I see the vacuum on daily basis. Being an adjudicator, at the same time being the in charge of mediation, Rajasthan High Court, Jodhpur, and knowing the process, I too had realized the need of a set of rules which could provide for broad principles and norms that can govern mediation. Furthermore, the stance taken by Justice D.Y. Chanchud is noteworthy, where he gives a caveat and suggests that mediation must be exercised with a bottom-up strategy, where unlike institutional culture with lawyers and judges in the center, the voices of oppressed are put forth without filter. I propose that the parties must be heard properly and they must have a chance to put forth their perils, and means might be adopted to achieve such purpose, be it by themselves if they are capable, or through a medium if they are not. Lastly, the power of courts and its way of working must not be looked down upon amidst the raising pendency and judicial procedure complexity uproar in the nation. The law courts in India have their own glory, and they have earned faith from the people all over these years, since before independence to this day. I am of the view that justice delivery cannot be separated from courts of law. The basic tenet instilled in the Constitution of India is procedure established by law, and the legal framework operative in India is framed in the most intricate and meticulous way. Speaking alone the lines of Honorable C.J. Shri N.V. Ramanna thoughts, it's a faith that people have on justice delivery through judiciary, which makes them believe that the court would come to its rescue if her rights is violated. When my Lord Honorable Justice Dinesh Maheshwari was Judge of Rajasthan High Court and Chief Justice of High Court of Meghalaya and Karnataka, his Lordship worked to strengthen justice delivery system. Under his Lordship guidance, Bangalore Mediation Center started working full time, and his idea of access to justice to the marginalized section suggests that the notion of mediation and ADR is an intelligent way of justice delivery, and it has gradually attained validation from the distinguished member of judiciary. I feel, my lords, after years of experience in the field, would be able to scrutinize the situation in the most precise way and enlighten us with his insightful thoughts. In fact, the genesis of ADR and the mediation is from the Law and Legal Process in India, Section 89, CPC being the origin and the ultimate aim behind such provision being lesser burden on courts and comfortable judicial delivery. Therefore, the bottom line is that there is a need to bring courts of law and mediation to common grounds so that their virtues can be conjoined and they can work in cooperation in order to achieve proper justice delivery. I would end my speech here. Thank you.
Thank you, sir. We are honored to have with us our patron in chief, Honorable Mr. Justice Indrajit Mohanty Saab. Now, I would like to request our patron in chief for his words of wisdom.
My Lord Justice Dinesh Maheshwari ji, my Lord, we welcome you home and we welcome you to our midst to once again listen and to your Lordship's kind address. My Lord Sangeet ji Lodha ji, my brother, Administrative Judge and Executive Chairman of RSLSA, my brother Justice Vijay Bishnoi ji, Chairman, Judge in charge of the Rajasthan High Court Mediation Center, Sri Brajendra Kumar Jain, Member Secretary, RSLSA, Director, and all of the RSLSA family, judicial officers from all throughout the state of Rajasthan, my brothers and sisters in the judiciary. I think today is a red letter day in the context of having in our midst Justice Maheshwari, for whose speech we eagerly await to learn from. And while welcoming you, sir, I earnestly request your Lordship and I, representing my colleagues and the entire judiciary at Rajasthan, we are here to learn from each other's experiences. And the process of learning is a never-ending process. I'm only grateful to Sangeet ji and to Justice Maheshwari for having given us this opportunity to learn. Thank you, sir. We look forward to learning. I have nothing further to say. My brother Justice Bishnoi has already introduced the topic. My brother Justice Sangeet ji Lodha has already addressed everything else. And I'm just watching on the clock. We're little 5 minutes late. So, Justice Maheshwari ji, we await eagerly for your Lordship's kind address.
Thank you, Lordship. Now the time has come for which we are waiting since morning. I would like to request Honorable Mr. Justice Dinesh Maheshwari Saab for his Lordship's keynote address. Honorable Mr. Justice Dinesh Maheshwari Saab.
Thank you. Thank you, madam. A very good morning to all. My esteemed brother, Justice Indrajit Mohanty, Chief Justice Rajasthan High Court. My esteemed brother, Justice Sangeet Raj Lodha, and the colleague judges of Rajasthan High Court. The learned Member Secretary, State Legal Services Authority, and his team at the authority. and above all, my dearest judicial officers of Rajasthan, ladies and gentlemen. No words of thanks I can express to the Rajasthan High Court and the State Legal Services Authority having given me this opportunity to be with you virtually, of course, by this medium and mode. This pious day of Guru Purnima, where we all bow to all our gurus, the teachers, and Brother Justice Manti has tersely but very aptly put just one line for all of us to remember that we all are learners. We continue to learn. We continue to learn from, and for that matter, we learn from each other. Then we learn from our surroundings. Then we learn from ourselves also. And that is how the life goes on, and and we go on progressing. Friends, the today's topic, Brother Justice Sangeet Raj Lodha had been in discussion with me about, and the idea was not only to talk about the importance or the relevance of alternative dispute resolution mechanisms, or for that matter, any competition between ADR processes and the regular judicial processes. But to remind ourselves about the requirements which are ingrained in our systems, where both these mechanisms, whatever varieties are there with us in the procedures made available to us since generations, to ensure that these processes, when we as judicial officers are required to deal with them, they do not pose any competitive or overmarching scenario for us, but we look at their synergy, their collaboration, their alliance, so that the ultimate goal of delivery of justice is ensured. That's why we chose this topic of synergy of these mechanisms, the collaboration of them, and particularly for we, the judicial officers, as to how to go about it. And for that matter, well, appropriate it would be to just have a look at the background, our ethos, our past, and then, as aptly put by Brother Justice Bishnoi, that whatever be the system, it cannot be separated from the regular courts of law. The delivery of justice is ultimately the concern of the court, and for that matter, when it is a concern of the court, anybody who is presiding over a particular court, a particular forum, well, the responsibility is definitely onerous. Then the responsibility definitely is required to be understood in the manner that, in the name of looking for the proper mechanism, we do not lend the cause or the persons or ourselves into more of questions, more of disputes rather than of resolutions. For that matter, the synergy is definitely required to be ensured that these systems, whatever be the system, they do not cut across each other, or they are not overlapping each other. but they proceed together. And together, when they proceed, and we are able to ensure that there is no conflict, there is nothing like alternative, even if the name ADR stands for alternative. Well, this is all of alliance. Friends, Seneca, a Roman Stoic philosopher, said tersely that excess in anything becomes a fault. Excess in anything becomes a fault. We always learn this, as we know in our mother tongues, particularly in Rajasthan. We also say, we are reminded by our teachers, our parents also. Ati har cheez ki buri hoti hai. Well, we have to ensure that we do not overdo anything. At the same time, we cannot afford underdoing the requirements of the ADR mechanisms. So we cannot allow our systems to be deprived of the advantages of ADR mechanisms. Again, therefore, we look at the synergy without underdoing or overdoing anything. Friends, Aristotle in politics posed a question. He asked if it was better to be ruled by the best leaders or the best laws. Aristotle found advantages and disadvantages to both these methods of governance, but in the end posited that the people should be governed by the best laws as opposed to the best leaders, with the reasoning that the laws were carefully thought out and could be applied to most situations, and they were more appropriate for the most societies. Whatever be the system of otherwise governance, if you have the best of the laws, well, the governance is bound to be smooth or is likely to fall in place even if there are any fault lines. Moving on, friends, to the requirements of a magistrate. That is how it was put, magistrate being a generic term, any judicial officer, the requirement of a judicial officer being there. Kautilya in Arthashastra has reminded us of the laws of fishes, the Matsya Nyayam system, where that proverb of fishes, where the big fish devoured the little during the periods of drought. And it was stated that, well, whenever there is an absence of a magistrate, the strong will swallow the weak, but under his protection, the weak resists the strong. As it was said, Baliyam abalam hi grasate, dandadhara bhave. If dandadhar is not available, well, the tendency would be of the stronger swallowing the weak. Existence of law to deal with a particular cause and simultaneous existence of meaningful administrator to ensure adherence to such laws has thus been highlighted and underscored by every relevant thinker and philosopher. Friends, existence of law or rules alone would never suffice. Its enforcement, whenever it is found wanting, the result would be as good as non-existence of such laws. When we are looking at our past, it would be opposite to remind ourselves of the great lessons available in our Smritis, particularly, where administration of justice was one of the most important and obligatory function of a sovereign, as it was indicated. The Smritis stressed that the very object with which the institution of kingship we can substitute for our understanding, being that of the sovereign, when in our people's republic, the people are the sovereign. But the principles could definitely be understood from the Smritis. The very object, as it was indicated in Smritis, was of this institution of sovereignship was conceived and brought into existence was for the enforcement of dharma by the use of the might of the state, and also to punish the individuals for contravention of dharma and to give protection and relief to those who were subjected to injury and in whose favor the law stood. The Smritis emphasized that it was the responsibility of the sovereign to protect the people through proper and impartial administration of justice. And it was more than once re-emphasized that such impartial administration of justice alone could bring peace and prosperity all around. It was cautioned that any indifference towards this function would bring calamity to the state and to the people. Rules of dharma were meant to regulate the individual conduct in such a way as to restrict the rights, liberties, and interests of an individual as regards all matters to the extent necessary in the interest of other individuals, that is the society. But at the same time, making it obligatory for the society also to safeguard and protect the individual in all respects through its social and political institutions. That is how Smritis would teach us. I'm coming back to that in a moment. Before that, with this preface, when we switch on, I just intend to switch on to ourselves to correlate some of the basic points which we need to discuss today. As is being indicated by Brother Justice Lodha also and other speakers also, the delays in administration of justice, delays in decisions, delays in a final adjudication in a cause is itself has always been a cause of concern. Now it is now it's not a matter of lengthy discourse that delay in determination of a cause before us practically renders the law and the rules meant for that cause redundant and rather otious. We revert back to that very well, the Mats Nyaya system, the rules of the principle, the proverb of fishes. I do not wish to repeat that rhetoric also that justice delayed is justice denied. However, one particular observation of a learned judge of the Supreme Court, I'm tempted to recite. It was in the case of Gaya Prasad versus Pradeep Srivastava, 2001-2 SCC 604. There a suit for eviction on the ground of bona fide requirement of carrying business by the landlord's son proceeded for many years. And during pendency of the suit, the son joined the service, and then decree for eviction was challenged on the ground that the son had joined the service. The requirement no longer exists. The Supreme Court said in that case that existence of bona fide requirement was to be determined in reference to the date on which the petition was filed. And the subsequent event would be considered only when the requirement or the need was fully satisfied. But that's not the point. The point is, in that decision, in that context, while taking note of the effects of long pendency of litigation, the Supreme Court inter alia said, and I quote, judicial tardiness for which unfortunately our system has acquired notoriety causes the list to creep through the line for long, long years, from the start to the ultimate termini, is a malady afflicting the system. During this long interval, when many events are bound to take place, which might happen in relation to the parties as well as the subject matter of the list. If the cause of action is to be submerged in such subsequent events on account of the malady of the system, it shatters the confidence of the litigant despite the impairment already caused. What I am emphasizing, friends, is the other paragraph in this judgment. And we need to remind ourselves, we need to continuously go on reminding ourselves the effects. The court said the time is running out for doing something to solve, and mind you, this was in the year 2001. The time is running out for doing something to solve the problem which has already grown into monstrous form. If a citizen is told that once you resort to legal procedure for realization of your urgent need, you have to wait and wait for 23 to 30 years, what else is it if not to, and that is very significant, inevitably encourage and force him to resort to extra legal measures for realizing the required reliefs. A republic governed by the rule of law cannot afford to compel its citizens to resort to such extra legal means, which are very often contra legal means, which with counterproductive results on the maintenance of law and order in the country. Friends, the dangers of denying justice at the relevant point of time or within reasonable time could not have been more seriously put in words by the Supreme Court. And we remind ourselves again, it was way back in the year 2001. It's not that justice delayed only denies justice. It leads to very many other maladies, the problems, and that tends to hit at the very root of the orderliness in the society. Orderliness, it's agreed to by everybody around the globe, is essential to the growth and development of a nation. For the rule of law to succeed, we had to strengthen the systems of delivery of justice. In our country, justice is mandated by the Constitution. The preamble avows of justice, social, economic, and political. But then, friends, we cannot think of delivering justice as a single dimensional exercise in resolving disputes alone. Conflict is a feature found in all societies, and how methods are developed to tackle is unique to them and to the socio-political and economic conditions of the time. But in our context, in the context of our country, the question of setting up a system that delivers speedy, reliable, and affordable justice to more than 1.3 billion people, that itself requires complex and at the same time a nuanced approach. Delivery of justice involves everyone from the person mopping the floor to the lawyers, to judges, police, legislature, and to the people who have laid their faith in us to act as impartial adjudicators. Friends, to continue the rule of law is to ensure delivery of justice. It would then not be inappropriate to reiterate that our trajectory as a nation is going to be determined by how we act in discharging our functions as adjudicators. With this, friends, I'm tempted to revert back to our ancient systems when we are talking about ADRs as one of the methods of ensuring delivery of justice to all. Ancient Indian jurists they bestowed great attention in involving the law governing the administration of justice. The provisions were made on the description of the highest court to be located at the capital city, of the lower courts under royal authority, and the people's court recognized as having the power to decide cases. It is the people's court I'm particularly emphasizing on, as you would notice. The qualifications of judges and the officers of the courts were prescribed. The appointment of experts as assessors to assist the court on technical questions was also provided. A code of conduct for judges and other concerned in the administration of justice was also provided. Significantly, for our understanding, a look at the acclaimed Smritis like those of Katyayan, Narad, Brihaspati brings to fore the important topic of gradation of courts, where it was provided that the court presided over by the king, again, you can substitute king for the sovereign, was the highest court. There were other courts. Some of them were appointed by the king and the others were people's court, recognized by the Smritis as having the power to administer justice. They were the courts of Kul. In English, they would write it Kula, K-U-L-A. Shreni, Gana, Gana, as they would be writing it. Adhikrita, and then Ripa. Rip, that is the king himself. These were invested with the powers to decide cases, and among them, each of the court mentioned later was superior to the one mentioned earlier. Looking a bit deeply into the significance of the people's courts, Kulla was an assembly of impartial persons belonging to the family or caste of the litigants, functioning as panchayatdars or panchayat mandali to decide dispute among those belonging to the same family or caste. That was the court of Kulla. Shreni was the next court. That was the court consisting of that was basically a corporation of the persons following the same craft, profession, or trade. The Gana was the assembly of the persons belonging to one place, but to different castes. The concept of the parties to the dispute settling their disputes in a binding manner by reference to a person or persons of their choice or the private tribunals, thus was well known to the ancient and the medieval India. The studies of Smritis would remind us, by the way, friends, about the traits, the requirements of a judicial officer, the oath to which we all ascribe to. They are found in Dharmakosha, like all these requirements of a judicial officer, who should be away from rag, lobh, bhay, dvesh. And the fifth one was very significant. These were the traits indicated as to when a judge may not be considered partial, or may not be considered impartial, I mean, and it may give rise to the charges of a partiality. When it was indicated that these were the 5 features: rag, that is affection; lobh, that is greed; bhay, that is fear; dvesh, that is ill will. And then the fifth one was very significant. That was described as Vadinoscha Rahashruti. That was the judge meeting and hearing a party to a case secretly. We would appreciate the oath which we take that has its roots in our fundamental legal systems. The same thing when we take an oath that we affirm that we would be functioning without affection or ill will, well, without fear or favor. So, friends, I would definitely request the State Legal Service Authority, as also the State Judicial Academy, the High Court, all to work again in synergy and to have in our discourses some of those fundamental principles which we find are not suddenly taken up and inserted by way of some provision like Section 89 CPC. They have their well-established roots in the smritis, the legal treaties, the fundamental legal systems. We have, of course, developed on them with passage of time and with the requirements. I may at this juncture, friends, before an overview of various ADR mechanisms in place, refer to a decision of the Privy Council, duly recognizing the value and worth of village panchayats, and essentially an informal but not binding form of justice delivery mechanism. The pertinent study would be of the case of Sitanna versus Viranna, reported in the AIR 1934 Privy Council, page 105. That particular case involved complex questions of fact, including the question as to one of the person was adopted as illegitimate son-in-law, as we know, Garjawai. That particular Garjawai system custom was recognized in Kama castes of and Reddys in Madras presidency. That particular case involved several of the complex questions about the property rights. But the significant part was that there was an award made by the panchayat, and in compliance thereof, a conveyance deed was executed in favor of that alleged Garjawai. I'm not dilating on various other questions of facts and law of succession, which I'm sure the learned officers would take trouble to go through if you are tempted to, and I hope you would look into it. The interesting point for our discussion is that in the appeal to the High Court, one of the judges of the division bench of High Court, Madras High Court, came to the conclusion that the panchayat's award was a bona fide settlement of dispute, which was binding on the estate represented by the widow who had executed the aforesaid conveyance in favor of that Garjavai. The Privy Council, mind you, it is 1934. The Privy Council agreed with that reasoning, and in that context, observed as follows. I quote, the Privy Council said, reference to a village panchayat is a time-honored method of deciding disputes of this kind and has these advantages that it is generally comparatively easy for the panchayatdars to ascertain the true facts, and that, as in this case, it avoids protracted litigation which, as observed by one of the witnesses, might have proved ruinous to the estate. Looking at the evidence as a whole, their lordships see no reason, that is what the Privy Council said, their lordships see no reason for doubting that the award was a fair and honest settlement of a doubtful claim based on legal and moral grounds, and are therefore of the opinion that there are no grounds for interfering with it. Friends, ordinarily in our justice delivery systems, a particular award, a particular decision has to be based on the legal grounds, and we are trained to imbibe that moral grounds as such, if not standing in tandem with the legal grounds, may not be justifying a particular award or a particular decision. But when it's a matter of panchayat, when it's a matter where a person is remaining answerable not only to his family or to himself, but to the society at large, the immediate society to which he belongs, the moral grounds also play a definitive role. And friends, these are those grounds which, as we know, we see, well, they play their own role in ADR mechanisms. Why I have referred to this 1934 decision of Privy Council and to Smritis is broadly to indicate that it is not that ADR mechanism is a particular procedure or a process which we have been handed down only by way of Section 89 CPC or by way of state legal services authorities or by way of lok adalats, etc. These are the systems ingrained in the overall justice delivery systems of our society. Proceeding further, from 1934, we may look at some of the other developments. It's not that it's alternative dispute resolution mechanism is something known only to the Code of Civil Procedure. We remind ourselves of the Industrial Disputes Act 1947. The first avenue in the later part of our codified laws, where conciliation was effectively introduced and recognized by the law statutorily as an effective method of dispute resolution in relation to the disputes between workers and the management. The provisions in the ID Act well made it attractive for the disputing parties to settle the disputes by negotiation, and failing that through conciliation by an officer of the government before resorting to the litigation. That was 1947. Family laws, the later development, has been recognized by the Family Courts Act, which provides for social welfare organizations to help the family courts, permanent counselors being there. We, when we study Section 89 of the Code of Civil Procedure, as I had been emphasizing, and we all know as the students of law, that Code of Civil Procedure is a study of the entire code as a whole. We cannot understand the system of the code by picking up one section alone or one provision alone. Even for the purpose of ADR systems also. When we, before even going to this section 89, we remind ourselves, friends, that Order 32 capital A was inserted to the Code of Civil Procedure by 1976 amendment, making provisions for the suit relating to the matters concerning the family. Rule 3 therein made it obligatory for the court to make efforts for settlement. Interestingly, the expression used therein is, if in any such suit or proceedings at any stage, it appears to the court that there is a reasonable possibility of a settlement. And that these are the very important and key words. Reasonable possibility of a settlement between the parties, the court may adjourn the proceedings for such period as it thinks fit to enable attempts to be made to effect such a settlement. It appears to the court that there is a reasonable possibility of settlement. Friends, switching on from proceeding further, I mean from 1976, we go to Section 89. We have been reading it all along, all through, understanding about the different ADR mechanisms, arbitration, conciliation, judicial settlement, mediation, and of course, read with the FCON's decision, which all of us are aware of, have been reading and rereading it to understand the nuances of the ADR mechanism and how to apply them. Friends, it is not my idea to dilate on Section 89 as such, or on the different mechanisms, but I intend to emphasize on the very first opening expression of Section 89 of the Code of Civil Procedure. When we look at the settlement of disputes outside the court, when do we look at it is where it appears to the court that there exist elements of a settlement which may be acceptable to the parties. Elements of settlement, again, we read them with reasonable possibility of settlement, the expression used in Order 32 capital A. Elements of settlement, they all are to be appearing to none other but to the court. And here lies the requirements of a judicial officer who is the presiding officer of the court as to how to look at the reasonable possibility of a settlement, or as crisply put, elements of settlement in Section 89. The court, Order 10, Rule 1A, 1B, 1C, all of us have been reading it. When the parties and reading it with AFCON's judgment as to what is basically required of us to do, as to whether we are drawing as such a settlement proposal or not. AFCON says no. We will look at a reasonable possibility of settlement, the element of settlement, and then refer them to either those kind of binding processes like arbitration or to voluntary processes like mediation, etc. Here, in our understanding of to complete the picture about the various venues where ADR mechanisms have been indicated, have been provided for statutorily. We remind ourselves of Legal Services Authority Act also, particularly where Lok Adalats have been given now a statutory recognition, and a settlement arrived at the Lok Adalats has been given the force of decree, which can be executed through the court. We have been reminding ourselves about the advantages of alternative dispute resolution mechanisms also, that they are cost effective, less expensive, less time consuming, free from the technicalities of the court. The parties are free to discuss their differences of opinion without any fear of disclosure. There is no losing or winning feeling among the parties. But at the same time, they are satisfied that the grievance is redressed, and as we are reminded of, the relationship of the parties is preserved. All these, friends, take us to understand as to what kind of matters are fit to be sent for ADR mechanisms. Regarding that, again, AFCON decision is a basic guide on which all of us have been proceeding. We are reminding ourselves about the impediments to settlement also, that when we look at the elements of settlement, the impediments like poor communication, the need to express emotions, different views of facts, different views of legal outcome, constituency pressures, linkage to other disputes, where a particular party is situated and what are the particular goals of the party. For a judge recommending an ADR procedure, the questions regarding these barriers to settlement are required to be gone into. One of the features a judicial officer always required to bear in mind is which may be militating against any use of ADR. First is that one or more of the parties may be incapable of negotiating effectively. That disparity plays a major role in the standing of the parties. The other features could be where the court procedure would be essential when serious questions of compliance or discovery would be involved. But then basically, for a judicial officer, there would be two lines of inquiry. What are the disputant's goals in making a forum choice? And if at all the disputants are amenable to settlement, what are the likely obstacles to that settlement? These all features, why I'm emphasizing these, friends, are required to be looked at, gone into, and understood by all of us any individual judicial officer in whatever capacity or grading is working, right at the junior division court up to the Supreme Court. Well, we have to be clear about that these are the features required to be looked at, to be understood, to be weighed before we put a particular matter in the process in any of the ADR mechanisms. There is no cut and dry formula. There is no straight jacket. Even these inquiries, which I had indicated, may not lead to a clear answer as to the question of forum and as to whether the matter should go to ADR or not. But then these inquiries for a judicial officer, when dealing with a particular cause, well, clarifies so many of the aspects, clarifies the fundamentals of the cause itself, the litigation itself, which would be helpful in ensuring that final delivery of justice, whether via ADR mechanism or ultimately by the court's order, as we know very many times, it does happen. When a matter goes to mediation, the ultimate settlement has to have the stamp of the court. For that matter, we remind ourselves of the requirements of Order 23.3 again, for the Code of Civil Procedure. The court has to be satisfied that the matter has been settled by way of a lawful compromise. Whether it is a lawful compromise or not is again a matter to be decided by the chair, by the presiding officer, by the person holding the seat of justice. Friends, AFCON decision, I need not elaborate on. We all know that the Supreme Court indicated how Section 89 is to be operated and what are the categories of cases which are normally considered to be not suitable for ADR processes and the category of cases which are considered normally suitable to the ADR processes, like not suitable matters like those of representative suits, dispute relating to election to the public offices, cases involving grant of authority by the court after inquiry, like the suit for grant of probate or letters of administration, cases involving serious and specific allegations of fraud. I'll come to the question of fraud a little bit later. Cases requiring protection of courts, for example, the claims against minors, DTs, mentally challenged, and the suit for declaration of title against the government, and the cases involving prosecution for criminal offences. The court also indicated which are considered suitable, like the disputes relating to contracts, specific performance, consumer disputes. We remind ourselves of the liberal provisions made in the consumer protection laws also. Dispute between developers, builders, customers, landlords, tenants, insurers, insured. Cases arising from strained or soured relationships, including the dispute relating to matrimonial causes, maintenance, custody of children, etc. All the cases relating even to tortious liability, including the claim for compensation in motor vehicle cases. Friends, after AFCON, there had been several further developments on law, particularly in relation to the different mechanisms. And today, I'm tempted to refer to one of the recent decisions of the Supreme Court. In the case of Avitel Post Studios Limited versus HSBC PI Holdings Mauritius Limited, 2020 SCC Online 656. I couldn't find this particular judgment having been printed in any of the regular law journals, but SCC online it is available 6/6. In that case, the court was dealing with the question as to whether the allegations of fraud can be adjudicated in arbitration. And that's a very significant decision. Or whether they require adjudication in the court, the questions of fraud. The court has laid down in clear terms that to determine whether the dispute involving the allegations of fraud is arbitrable and when it would require adjudication, when it would be arbitrable and when it would require adjudication before the court. It has been held that as long as the arbitration agreement is found to exist, mere allegations of fraud or initiation of criminal proceedings would not render the disputes to be non-arbitrable. It's only in those cases, those rare situations, where the contract containing arbitration clause is found to be void that the arbitration clause would also cease to exist. Inter se allegations of fraud by one of the parties merely render the contract voidable under Section 17 of the Contract Act, and applying the principles of separability of arbitration clause or agreement from the underlying contract. Parties cannot be permitted to avoid arbitration merely on the basis of such allegations of fraud. The court referred to the decision in the other recent decisions in the case of Rashid Reza versus Sadaf Akhtar, and it was held that there was a distinction between serious allegations of forgery or fabrication in support of the plea of fraud as opposed to simple allegations. And there is a beautiful distinction made about this serious allegations of forgery and simple allegations. And it was held that whether the plea permeates the entire contract and above all the agreement of the arbitration rendering it void, and whether the allegations of fraud touch upon the internal affairs of the parties inter se, having no implications on the public domain. After noting such judgments, the Supreme Court held that the serious allegations of fraud would arise only if either of the two tests were satisfied and not otherwise. In Avian, the Supreme Court has pointed out that the AFCON decision, as also the later decision in Booz Allen, should now be read subject to the rider that in the same set of facts may lead to civil and criminal proceedings. And if it is clear that the civil dispute involves the question of fraud and misrepresentation, which can be subject matter of such proceedings under Section 17 of the Contract Act, or the tort of deceit, the mere fact that the criminal proceedings can or have been instituted would not lead to the conclusion that a dispute ceases to be arbitrary. That is reinforcing the seriousness of the law of arbitration and its enforceability. The court, repeated, the court held that there can be a distinction between a contract obtained by fraud or the performance of contract being initiated by fraud. The second category of fraud, which vitiates the performance of the contract and would be governed by the tort of deceit, leading to a claim of damages and not of rescission of contract itself. However, the court held that both kinds of frauds are subsumed within the expression fraud when it comes to arbitrability of an agreement which contains an arbitration clause. Friends, this and other decisions and the development of law makes one thing clear, that when there are alternative mechanisms either agreed to by the parties, arbitration here in this case, or where the court would see that alternative mechanisms are required to be resorted to, well, we do allow, or rather, we do put the matter in the process of ADR mechanism, particularly like that of arbitration. But when sending the matter to mediation, well, the requirements are that it is all for the chair, the judicial officer to take into account all those elements operating for or against a reference to mediation, and then only refer the matter to mediation, not referring the matter just for the sake of referring it or just for the sake of sending it out of our regular process of the delivery of justice in the court and out of the regular proceedings. The time spent, as we are told, we remind ourselves, the time spent in an unnecessary mediation, that is essentially counterproductive for the purpose for which we all are looking at the ADR mechanisms. If a matter it doesn't have the elements of settlement, it is not sent to the ADR mechanism. We do not send the matters to ADR only for the purpose of sending it or only for the purpose that, we feel it, that there is a bounden duty to send it. There is definitely a bounden duty to examine that, but what is to be examined are the elements of settlement, the reasonable possibility, the reasonable chances of settlement. And for that, the parties, the nature of the parties, as also the nature of dispute, the nature of cause, are the things always required to be looked at, examined thoroughly by us. And that is why we remind ourselves again and again, particularly when we are whether we are dealing with the matter at the trial level, at the original level, or we are dealing with the matter at the appellate level, to be very sure of the issues arising for determination at the trial level and the points for determination arising at the appellate level. Once we are sure as to what points are arising, we are sure about the parties, the respective goals of the parties, the respective standing of the parties, the disparity of the approach of the parties. But at the same time, those elements where they could be made to converge on a solution. Looking for the solution, the standing of the parties, as also the nature of cause. There are certain causes which do require ultimately an adjudication by the court. And even if there are elements of settlement of which we may be jumping on, or we may suddenly find on the surface of it, we may ultimately find that even those elements will not be sufficient, would not suffice, because ultimately, even for the public law, a decision by the court is needed, particularly something like the new enactments, particularly like new legal rights, the legal and the duties and responsibilities which are required to be defined by the courts in the operation of a particular statute. Whatever be the mechanism that may not serve the purpose of the disputants as also the purpose of the society. But yes, after this filtration is done by us, after conscious filtration is done at the level of Section 89, that is at the level of Order 10, the examination of the parties, when we consciously look at the elements of settlement spread, and consciously, what I mean to re-emphasize is that we have to examine deep, not only to the cause, but to the parties also, and their comparative standings also. And thereafter, with that deep examination, don't send if it's not going to be of a use, but yes, do send it when elements are there. Thereafter, it is the process when you send it to say something like judicial settlement, for which you send the matter to another judicial forum who can we understand, because even the mediation training, many of our judicial officers have also been imparted with the training to work as mediators. So in those trainings, we are given to understand the various features of the particularly the psychological features as to how do they operate and how the stumbling blocks to be taken care of, to be tackled, the impediments to be removed, and that is these are the areas of functioning of the trained mediators, and for that matter, mediation or judicial settlement or even lok adalat, when you are able to reason with particular person, the party concerned, and making it sure that the party concerned ultimately takes it from the entire system, whether it is our ADR process or it is the judicial determination or it is a combination. And usually it has to be, and it is the combination of both. Well, the party concerned ultimately takes not only the redressal of grievance, but coupled with that, a satisfaction. And once the party takes the satisfaction, well, that is what we all exist for. That is what we stand for. Yes, there is a corollary part of it. I had seen in mediation, particularly in mediation exercises, as it has been rightly indicated, the Honorable Chief Justice of India very recently again reminded of the mediation being one of the most well, quick, inexpensive, and convenient method of dispute resolution. In his recent speech, yes, we do. I had, thankfully, I had the opportunity to be a part of mediation center as judge in charge mediation at Jaipur, participating in those mediation trainings, and we found that even the persons who were skeptical about the utility and worth of mediation after participation in those mediation trainings, those 40 hours trainings as they started, well, found themselves to be changed personalities. Our approach, our perceptions changed when we started employing the tool of mediation effectively. When we understood the effectiveness of the tool of mediation as to how it helps in very many ways. Friends, one of the significant features I noticed was that when a matter goes to mediation, but again, mind you, elements of settlement existing is the first requirement. If the matter has come to the court, we are not there could be the features of pre-litigation mediations also, which are being done. Pre-litigation, anything before it has entered into the court to be taken up in the mediation or lok adalat, and the parties coming out with a solution, that is also not unknown, and it is also gaining momentum, and it will gain further momentum. What we remind ourselves, what was the interesting feature of mediation exercise was that when we took the parties to mediation, even if ultimately the mediation didn't succeed, and it may not succeed for a variety of reasons, the interesting feature was that the parties, after having gone through the mediation, they themselves in their approach were the changed personalities. Several of the misgivings were taken out. Several of the doubts were absorbed in that very process of mediation. And that also helped, even if not of a settlement by way of a mediation, that helped in, well, deciding the matter in the court of law, where several of the irrelevants were shunned off, several of the unnecessary baggages were taken out or left aside, taken out by the system or left aside by the traveler himself. that itself serves a great deal, that itself helps a lot when we allow a matter to be sincerely, seriously dealt with in mediation. Mediation is gaining momentum. Mediation, we are having good success rates also. But the feature which I have noticed is that even if a settlement by way of mediation doesn't come up, a sincere and a methodical involvement of a mediator and a mediation exercise, not for the purpose of forcing any settlement, but for the purpose of, well, allowing the parties to shift from their rigidity, shift from their stand, and to come to a particular level where at least the task of a judicial officer, when the matter goes to the court or any other adjudicator, well, that is eased in the manner that you are required to deal with only the material part of the material propositions, as we are told when we are to frame the issues in a litigation, we have to look at the material propositions, and it's definitely a challenge for a judicial officer to, well, sift out from the things which have been presented to all of us, to look at and find, to take out the material part of the propositions. The processes are not unknown, friends, that when a matter goes to arbitration, even in arbitration, the matters are referred to mediation, and then we get a mediation settlement being presented to the arbitrator and an award coming out of that. So the point is, finally, that none of these processes we look at as standing in different compartments or, well, detached from each other. They are the part and parcel of, they are united in their operation, they are together, and we are the judicial officers, we as judicial officers take them as a whole combo pack, a whole lot together, and thereafter pick whatever is the best suited mechanism, whatever is best suited for for a particular cause to a particular person and cause, both order 1 and order 2 of the code of civil procedure. That is why they stand in the first. Well, they reign the ultimate, the first. They stand at the first. We have to be sure about what the parties are, means what the standing of the parties is, and then what the cause is. So, friends, finally, I would say, in whatever capacity you are functioning, and some of you do function as mediators also, or the officers in the Lok Adalats also, and of course, the core work of the decision in the court. In whatever capacity you are functioning, the synergy of all your skills is also needed. The combination of all of your skills towards regular processes and the ADR mechanism is needed. If I can put it that way, a 360-degree approach, an approach where every aspect is taken note of and none of the aspect is left aside. That is needed. Once we are sure of that, once we employ, well, these skills, we'll find, friend, why I reminded about 2001 decision and even the older decisions and the present day scenario. Friends, ultimately, it's delivery of justice that is the concern of all. As somebody very tersely placed it during my yesteryears as lawyer, when one of the lawyers reminded a judge, very rightly so, it's निर्णय करने में और न्याय करने में फर्क होता है. There is a always a difference between deciding a matter and delivering justice. Yes, we do decide, but we do decide not only for statistics purposes. We decide for the purpose of delivery of justice. And when it is delivery of justice is our concern, well, we look at the thing from every possible angle and thereafter, well, choose the we provide for the path particular litigation ought to take, whether in the regular process or in the ADR mechanism. And again, we remind ourselves also that there is no cut and dry, there is no straight jacket. And today, a particular ADR mechanism may appear to be well not workable, non-workable, or may not be suitable for a particular matter to go. But then, during the progress of the matter, also, well, we may find that well the elements of settlement has started spurting up, coming up, being generated, or somebody seeing a reason. So well, these are ultimately in all our files exist the human beings, the persons, and when the persons are there, well, the possibilities are infinite. We always remind ourselves of those infinite possibilities, and thereafter, well, well, we keep on proceeding further. Well, every day is a new day, and we look for a better tomorrow. Friends, as it was, I would conclude today with a very interesting saying by Heraclitus, the great Greek philosopher of pro-Socratic era. He was known for his insistence on the ever-changing change or flux. He aptly described, he said that no man steps in the same river twice because it is not the same river and he is not the same man. It flows, things keep on flowing. That is the flux, that is the law of nature, that is the law of human beings. So we all look for a better tomorrow. We ask ourselves and we tell ourselves, we promise to ourselves that well, every day we would look at the thing again from open-minded for another possibility. As we as judicial officers, we are trained for trained to make sure, trained to understand that there is always another possibility. So there is always possibility for a better tomorrow in these pandemic times. Well, where the judiciary has been well making all efforts to ensure that despite all challenges, delivery of justice is well ensured. It keeps on going, providing with these virtual notes or whatever methodologies at our disposal, as it was indicated, even the online lok adalats. Well, when the online systems are there to stay and online systems are being well accepted, people getting tuned to it, we all getting tuned to it. Well, even the ADR mechanisms, well, that also all the mechanisms are being successfully or more methodically done in these virtual modes in the times to come. That may ensure that even when this pandemic is not there, well, the lessons which we have learned here and the new skills which we have developed here, they would be of our assistance. They would be, or they would further guide. They would further take us further to do better than what we had been doing yesterday. So thank you so very much. We look for the synergy of everything around us, not only the ADR and the judicial processes, the synergy of all our skills, all our understanding, well, and the synergy of all of us. It is, as has been the motto, justice for all and one for all for one. Well, that is what the motto always has been of our society. we keep that always in mind and keep on proceeding further. Thank you so very much, everybody. Thank you.
Thank you, Lordship. Lordship has beautifully explained, that is legally and philosophically, how to maintain synergy between two modes of dispute resolution. Aristotle has also said that mediation is an essential tool for a judge, as it is he who would establish equality. So I don't think there exist any doubts in the mind of our officers, as Lordship has meticulously dealt with the topic. But few of our officers are having doubts in their minds related to today's topic. So first, with the permission of the chair, may I open this session for question and answer, sir?
Most welcome, most welcome. Yeah.
Thank you, sir. So I would request Ravi Kanji to make Shri Vikrant Gupta, sir, District Judge Sirohi, presenter or a panelist, so that sir may ask his question.
My Lord Honorable Chief Justice Inderjeet Mohanty, My Lord Honorable Justice Sangeet Raj Lodha, and all Honorable Judges of Rajasthan High Court, Lordship. We all, the judges of subordinate judiciary, on the today's auspicious occasion, Lordship, of Guru Purnima, seek the blessings first of all for today. Now, my Lord, I have been fortunate enough to go through the lecture of Honorable Justice R.V. Ravindran, former Judge, Supreme Court of India, who has delivered the judgment of AFCON, Lordship. And a detailed lecture was given by his Lordship, in which he has pointed out the difficulty of the judges, the difficulties and reluctance of advocates, difficulties and reluctance of litigants in going through the ADR processes, Lordship. Being district judge, I am also facing the same difficulties, though, which have been in detail pointed out, Lordship. And when we are dealing with the cases in the trial court, Lordship, there are large number of cases listed on a particular day before us, Lordship. And we have to give enough time to almost each and every case on the day. When, Lordship, we are dealing with a case when which alternative dispute resolution can be done, Lordship, then we find sometimes that the advocate insisted upon, if brought together, if the litigants brought together, can have a meaningful dialogue. But sometimes when we are asking them to come forward, then they say, my party is not here, my party is not here, we fix another day, Lordship. And on the other date, either one doesn't turn up or all doesn't turn up. So the meaningful exercise which we are doing on the particular day goes waste, Lordship. So this difficulty is regularly being faced by us and by the similar manner by the lawyers also, who are inclined to go into the process of ADR, Lordship. This is the difficulty. And my Lord, my another submission would be in this regard, that today the communication and technology is rising, Lordship. Earlier, this was not so much on rise, and now during the Corona period, we are going through the online discussions, online hearing. So can we go, Lordship, for the online talking with the litigants and parties and advocates on the same platform as we are dealing with the arguments on Corona period, Lordship? Because unless and until that is being provided and that facility is given to us, being judicial officers, we may not be able to do and use the communication technology skill which is available to us practically, which is available to us, and it is being widened also, Lordship. So some sort of directions may kindly be given to each and all, Lordship.
And thank you, Mr. Gupta. So far as giving of any direction part is concerned, so far as I am concerned, I am out of High Court administration now. So that can only be well commented upon or said by the Honorable Chief Justice and Honorable Justice Loda. So first of all, I would request them both or any of them to respond to some of your points, and then definitely I'll come to it. I'll come to it. Whether Justice Mohanty or whether Justice Loda, anyone would like to make any comment, I'll come to Mr. Gupta's point then.
No, we have already adopted online method also for the purpose of the Lok Adalat, and now Lok Adalats are being conducted by a hybrid method. So it's not that the mediators also cannot be conducted by way of hybrid method. If the party is not present, obviously that can be contacted online during the process of mediation. So we can adopt that. So only that all the centers are to be equipped for that. And the process is on. Shortly we will be able to just establish online gazettes everywhere. That is all.
Yes, adding on, so Mr. Vikrant Gupta, that is from your administration. Now, from me, see, these days you must have noticed even the proposal for live streaming of the court proceedings is afoot, and not only afoot. In fact, Gujarat High Court, the Honorable Chief Justice of India inaugurated the system a few days back, and there are things which are taking shape and progressing every day. As I said, every day we are proceeding ahead. Brother Justice Loda rightly pointed out that when we are having online Lok Adalats, we are having other online mechanisms. So far as your this query or your this doubt as to why can't you, or whether you could interact with the parties online or not. Frankly speaking, speaking for myself, I don't see any problem or doubt or any question with that, because ultimately all of us exist for that litigant. As I said, it is ultimately that litigant who resides in the papers of our files. These are not simple papers; they are human beings in it, and we are for the purpose of delivering justice to them. So interacting with a litigant or a lawyer, as we are doing it online, well, I don't see any difficulty so far as all other measures are taken care of, all other requirements are taken care of. For the purpose of interacting, for the purpose of the cause and interaction, a judicial officer would be looking at and can reasonably do it. But yes, so far as your initial comment was concerned about the hitch on the part of a particular litigant or a particular lawyer or a particular advisor, or for that matter anyone, well, that is a feature, that is a particular area of challenge which is being means dealt with by all of us in every form of the functioning of the court, or even litigation or pre-litigation or the Lok Adalats. So there could be, again, that is why, well, standing of a particular party, his goals, we need to, take into account, we need to understand, and thereafter look at the possibility of settlement. This is like one party may be very, very keen to say and would be projecting, has been projecting, it does happen, that well, sir, मैं तो compromise करने के लिए तैयार हूँ, लेकिन वो नहीं करता. Kind of these syndromes. Well, that is, it is, we can't talk in terms of मैं, that I am ready. When we are talking of settlement, it has to be always we that should be talking, and that we would include both the disputant, the persons standing on the different sides, unless they converse. So if there is one party, there are all elements of Mr. Vikrant Gupta. If there are elements of settlement available, one party is absolutely keen to have the settlement, and another party is absolutely rigid and clear that, well, come what may, I want a decision from you, sir. I don't want a settlement. And that is what his standing is. You may try to reason, you may try to talk, you or any negotiator, any mediator, anybody may try to talk. The person doesn't change his stand. Well, you can't stretch a thing beyond a point. That's what I indicated right at the beginning. Well, excess of anything would become fault. You can't go on, well, wasting your time, because your time, that is the court's time, it's people's time, sir. It is public time. Every single minute of your court, our court is not your or my time, sir. That is the time belonging to the people for whom we exist. So we give a try to everything to the best of our ability. If it cannot happen, well, ultimately it is for us to proceed with it. A settlement is ultimately a two-way affair. It is from both the sides. So we try our best, and we have to leave it when the thing doesn't happen. Because again, I remind you, if it is not happening today, it may happen tomorrow. Even after a statement of the plaintiff, the defendant may come and say that, sir, I want a compromise now. You will not say that कि तुमने कल मना किया था, therefore I will not do it today. You will do it whenever it happens. So these are the dynamic processes, sir. They keep on happening. Thank you.
Thank you, Lordship. I think Vikrant sir has got the solution to his question. I would request Honorable Mr. Justice Sandeep Mehta साहब, sir ने side panel पे डाला है how he could Lordship could manage mediation or settle the dispute through video conferencing. Honorable Justice Sandeep Mehta साहब.
Yes, please. Yes, please. I don't know. Not hearing anybody.
I'm sorry, I'll not be able to speak out. There's a network issue here. That's why I put in a chat that in the previous Lok Adalat, we used this method, joint parties at 3 different districts, and managed to settle the disputes through mediation, which we conducted from Jaipur. So this is a very easy solution. Then the parties are not required to travel down, and from the remote location we are sitting at High Court. And from the we use the VC rooms of the district courts. The parties were called there, and we intervened, or rather mediated from Jaipur, and ensured dispute was settled. So what my lords were saying, this is a simple solution which has been successful, sir. So far as we are concerned.
Yeah. So it can be. That is what I am indicating. These are the tools now at our command, and even there is a development of the tools. You find daily updates of your softwares or not. You keep on updating. See, update is not for computer alone, sir. A daily update is for all of us, sir, and we keep on proceeding. Yeah.
True, my lords. Yes, sir.
Yeah.
थैंक यू सर. अगला प्रश्न आ रहा है हमारे सेक्रेटरी डिस्ट्रिक्ट लीगल सर्विसेज अथॉरिटी भरतपुर श्री अजय गुदारा साहब की तरफ से. मैं रविकांत जी को रिक्वेस्ट करूंगी कि अजय गुदारा साहब को पैनलिस्ट में डालें.
My Lord, Honorable Justice Mr. Dinesh Maheshwari, Judge Supreme Court of India, Honorable Mr. Justice Indrajit Mohanty, Chief Justice Rajasthan High Court, Honorable Mr. Justice Sangeet Raj Lodha Saab, Judge Rajasthan High Court and Chairman Rajasthan State Legal Service Authority, and other honorable judges. Very good afternoon to all. Sir, my question is based on problem we face during mediation. सर, जैसा कि हम सभी देखते हैं कि जब हमारे पास एज ए मीडिएटर कोई केस रेफर होके आता है, ऐसे केसेस जो फैमिली मैटर से रिलेटेड है, और उसके साथ कुछ कनेक्टेड मैटर्स और रिलेटेड मैटर्स भी होते हैं, लाइक एज डोमेस्टिक वायलेंस केसेस। तो सर अक्सर ये प्रॉब्लम एक मीडिएटर के रूप में मेरे सामने आई कि जब मैंने मीडिएशन शुरू किया दोनों पार्टीज का, और उन पार्टी से उनकी जो इश्यूज थे वो लिए कि क्या क्या इश्यूज उनके बीच हैं, तो ये चीज भी सामने आई कि कनेक्टेड मैटर्स और रिलेटेड मैटर्स जिसमें अदर पार्टीज भी इन्वॉल्व है, जैसे हस्बैंड के मदर, फादर, बहन, उन वो डोमेस्टिक केस वायलेंस के केसेस में इन्वॉल्व थे। वो केस हमारे पास रेफर होके नहीं आता। अब एज ए मीडिएटर सर हमारे पास कुछ लिमिटेशंस हो जाती हैं कि जो पार्टीज हमारे सामने नहीं आई हम उनसे कैसे कम्युनिकेट करें। तो माय फर्स्ट क्वेश्चन इज सर कि यदि कनेक्टेड और रिलेटेड मैटर्स जिनकी पार्टीज हमारे सामने नहीं आई है, हम उन्हें मीडिएशन में कैसे इंट्रोड्यूस करें, कैसे आमंत्रित करें। नंबर 2 सर, मीडिएशन रूल्स हमें ये भी प्रोवाइड करते हैं कि जिस कोर्ट से हमारे पास मीडिएशन रेफर हो गया है, रेफरल जज से, हम उनसे तो कम्युनिकेशन कर सकते हैं। तो दूसरा मेरा प्रश्न ये है सर, क्या हम ऐसे कोर्ट्स जो कनेक्टेड और रिलेटेड मैटर्स का ट्रायल कर रहे हैं, क्या हम उनसे भी कम्युनिकेट कर सकते हैं?
Yes, please. Yes, Mr. Godara, thank you. When again, may I request the Honorable Judge in charge mediation centers, whether at Jodhpur or I understand there are judges in charge at mediation at Jodhpur and Jaipur, right?
Yes,
Yes.
yes, sir.
I had the opportunity to work for few years as judge in charge mediation. So judge in charge mediation may make a comment. I'll come to it. I'll refer to this question. Yes, please.
So far as regarding, sir, mediation in respect of the other courts are concerned, for the cases which are pending in the other courts are concerned, as such, there is no such guideline, but at least if the court which has referred the matter to the mediation, for mediation, that court can communicate with the other courts, or if particularly if the High Court has sent it for the mediation, then I don't think so there is any problem. The High Court can always call for the other cases pending in the subordinate courts and ask the parties concerned to get the matter resolved through compromise, even if some other parties are also there, sir. But so far as regarding these lower courts are concerned, certainly this can be a problem where a particular a case is pending in a particular court and other case is pending in relation to other relatives in some other court. For that, I don't think so there is any such method which can be to solve this problem.
Friends, this particular aspect, thanks to Mr. Godara having put this question. In fact, there's not much of a problem, though it appears to be a problem on the face of it, appears to be having some issues of its own. But before coming to that, the other day when Assam State Legal Services Authority has conceived this program, and I had an opportunity to discuss a few basics with Brother Justice Sangeet Lodha. I had a query because I remember as a judge of the Rajasthan High Court, we were aware of the alternative dispute resolution rules framed by High Court in the year 2004. If my understanding goes correct, maybe there were certain proposals afoot to have the fresh rules and rules being amended. Uh, I think if they have not been amended, which I have not been able to find the amended rules. If they've been amended, I would be thankful if I'm shown that. And if not amended, then well, to my mind, this is high time that we amend those alternative dispute resolution rules, because they were framed way back on 6th April 2000. They were notified on 6th April 2005. Uh, so much of development has taken place thereafter down the line, these 15 years, 16 years. And these rules they may require republishing. This aspect or any such aspect, when these rules are being amended or recast, these aspects could definitely be taken care of or provided for in the rules. But well, not existing the rules, and in the present scenario, friend, Mr. Godara and all my friends, what I have noticed, well, mediation or any exercise of under of ADR mechanism. Idea is to provide for a solution for all time to come for all persons in an effective manner, where the what we provide is a resolution of a dispute with nobody winning kind of a situation and everybody getting satisfied. Where wherever there are disputes, taking any dispute in the form of A versus B or 1 versus 2 is not correct, and we all know it. There are different interest groups, there are agnates and cognates connected with a particular dispute. So when we look for a solution, even and it happens, and so far as this mediation is concerned, we all understand mediation as absolutely a confidential process. It is closed door process. What the parties discusses with you, what you discuss with the parties, what transpires in the course of mediation, well, nobody is supposed to know. Well, this is the confidentiality is the hallmark of mediation. So in that process, when you are in the process of mediation and the different sessions which you hold, it is not unknown that in those sessions, apart from the parties, the correlated, connected, agnate, cognates, the correlated persons, you allow the parties to talk to themselves or to talk to you also. You even take note of, say, for example, this kind of a matrimonial dispute. There may be a scenario where a particular person may not be having much of the dispute, much of the grievance against the spouse as such, but maybe having a dispute or maybe having a question mark about one particular behavioral pattern or one particular objectionable aspect concerning a person related with that spouse. Well, they're allowing the parties to come to a settlement if there is such kind of a particular grievance syndrome remaining, which could be taken care of by allowing the parties to talk. A simple namaste or a simple talk or a simple cup of tea has done wonders. But that all is permissible in mediation. So it is on the impunity of a mediator. It is on a mediator is always supposed to think out of box. A mediator, that is what the training of a mediator has always been. That you look for the solution beyond all the solutions which are apparent. That is where thinking out of box comes into play. So this is not much of the thinking out of box, allowing a particular person who even if not a direct stakeholder in a litigation, but a role player in some of the features of the call, to have his own say in the matter, or allowing a particular misgiving or doubt or dispute or a grievance to be taken care of by way of mediation. A mediator can always do it. Now, so far as the other multiple litigations are concerned, live at different places are concerned, once again, in a mediation, what you do is that you take the parties to the solution. You are not a conciliator. That is how we try to differentiate and understand. You are not suggesting a particular solution. What you do is that you allow the parties to evolve their own solution and to converge to a particular meeting point by which the solution comes up. If that is the I mean that is what the mediation is meant for, and that is what the mediator is working at, then you can allow all these aspects to be taken care of by the parties. And you may find sometimes that the parties do come out of their own solutions. But thereafter, if there is a particular matter which relates to domestic violence matter, or which relates to any other matter which is pending in any other court, well, it could, to my mind, one of the solutions, it could definitely be, well, means indicated to the judge in charge mediation. I understand that there must be a mediation in charge in every district, as we were having, and you must be having, or the person in charge mediation, or the district and sessions judge for that matter, who is the controlling authority on around your district, or for that matter, it could be indicated even to the High Court. Because see, everybody, all of us, in whatever capacity we are working, well, the idea is, well, whenever we are looking at the ADR mechanism, all of us are tuned to see to it that if a solution or a settlement is a possibility, all of us, individually and collectively, works towards ensuring that solution. We are not standing at a blockade, we always remove the blockades. So, in a given situation or scenario, the blockades could always be removed with the concerned parties first, the concerned court second, the judges in charge third, the controlling authority fourth, the High Court for that matter in the final. So the methods can be evolved, but that will depend on the particular case. But again, reverting back to it, I think the point which is made by Mr. Godara could be taken note of by the authorities concerned, and when the rules are being republished or made again, made anew, these aspects could be taken note of and provided for in the rules. Thank you.
Thank you, Your Lordship.
Just I want to just add on the issue.
Yes.
As suggested by your lordship, this ADR mediation and conciliation rules of Rajasthan High Court was framed into the year 2004. Much water has flown thereafter, and now these rules need to be amended, and we will be taking up this issue shortly. But so far as this communication part is concerned, communication of mediator with the court, there is already a provision incorporated under the rules, that is Rule 22, that provides that mediator can communicate with the court, and in what manner he can communicate, that is also provided. And second, the issue which is raised regarding the mediator contacting other party. So there is no prohibition or inhibition under the law that the mediator cannot call third party also for,
Right.
for the purpose of conciliation and settlement of the dispute.
Right. That is what we indicated. Right. Thank you. Yes.
Thank you, Your Lordship.
Thank you, Lordships. Next question is coming from Ms. Meghna Jain, Joint Secretary, RSLSA, Jodhpur. Ms. Meghna.
Good morning, Honorable Justice Dinesh Maheshwari Sir, Judge, Supreme Court. Honorable Judge, a very good morning to everyone. I do not have a question, and today on this auspicious day, I would just thank all my gurus who are sitting here. Sir, we did not learn and listen from you personally every time, but your judgments have taught us a lot. Sir, today, sir, you talked about, in your kind discourse, you talked about right from the roots to the recent judgment about the alternative way of dispute resolution and the synergy between the adjudicating system. I do not have a question, sir. I have a little suggestion that your lordship talked about the statutory recognition of Lok Adalat. Many countries like Ireland and Singapore have already codified mediation as a law. So my suggestion and submission is that we already in our country has conciliation and arbitration as a codified law. As your lordship said, this Lok Adalat has got a statutory recognition. Sir, is it not the time to talk to Law Ministry about the issues to make mediation a codified law? Thank you, Lord.
The codification, thank you, Megnadeep. Well, what legislation is to come up is an area, obviously, for the other branch of the state, that is the legislature, to look at. We find that mediation, the word mediation, got inserted in our statute book for the first time by way of insertion of the same in section 89. But then, as I indicated, and that is what we all understand, there is nothing in as such in the name mediation, that is extraordinary about. Well, the exercises, though we have given the different processes for the purpose of, different procedures and different methodologies being there, the different names. But all said and done, and of course, the methodology is being different because mediation is a unique procedure where nobody suggests any solution and nobody suggests nobody forces any solution. What we try is that solution is evolved by the parties alone. But barring that particular one distinctive feature, the other features, all the features remain more or less the same, whether it is conciliation or whether it is Lok Adalat, even judicial settlement, whatever we look at, even in the ordinary course also, a simple one word from you, from a judicial officer, from you, me, any one of us, अरे भाई ये तो इतना सा मामला है आप लोग सेटलमेंट क्यों नहीं कर लेते हो, kind of this particular statement or anything of that nature, अरे इसमें settlement हो सकता है, kind of, that particular impulse of ours, basically triggers basically that elements of settlement when we see and we suggest. Now, thereafter, it may go to mediation. It does go to mediation. We do go for the mediation. But then mediation process itself is a structured process. There are methodologies for how do we go about mediation. But thereafter, inside mediation, what would happen, how we will do it, we are not having any rules exactly telling us as to, these are the things to be done or to not to be done in mediation. Anything tomorrow happens when a litigant, even after mediation, some element of dissatisfaction remains, and your mediation exercise or mediation settlement is also challenged by way of non-compliance of a so-called a particular provision of the rule, and then we go on debating whether that rule was mandatory or directory, etc. Means, these are the ingenuities, and these are the things which we all are attuned to it. They keep on coming in our courts. So there is nothing which is at present working against mediation as such. Otherwise, beyond that, whether a particular statute or a particular methodology or rules or anything insertion in the existing statute is to be done or not, that we have to leave it to the wisdom of the legislature. And until this time, whatever is available to us, since there is nothing of anything detrimental or prohibitive regarding our exercising any of these options is operating, we can, by way of course, the relevant rule, as Brother Justice Loda has rightly indicated, the recasting of the routes is in the offing. That could be taken care of. As at present, that may suffice. Rest all for legislature.
Thank you, Lord.
एक सेकंड में बोलना मत
Brother,
Yes.
Sir Justice Bhati will say, seeking to say something, raising his hands.
Yes, sir. Sir.
Sir, my question is, sir, when we were trained as mediators, when you were the mediation in charge, an opportunity was given to us to be trained as mediators. At that time also, your views were that the pre-litigation mediation is an important tool for providing direct relief to the society. And I remember that on many occasions, my lords were having a clear view that this should happen. Thereafter, also, all of us have seen the mediation growing in Rajasthan. Mediation center is working and it is working well. But the pre-litigation mediation has not been, really, I mean, come in Rajasthan, whereas it is there in number of states. So what do you think, sir, that we should do to develop this particular branch of mediation?
Brother Justice Bhati, so far as pre-litigation mediation is concerned, you rightly indicated we had spent, apart from those 40 hours of training, we have spent so many hours appreciating the beauty of this system of mediation. And all of us, one way or the other, is employing it to the given situations and scenario. Coming to pre-litigation mediation, again, there are two features which play a big role. As you say, it is not taken up in Rajasthan. It is not only in the state of Rajasthan, but there are several other states and several other societies where the pre-litigation mediation or pre-litigation, any kind of, even pre-litigation lok adalats or pre-litigation, anything which could be nipped in the bud or could be taken care of in the beginning. But that all depends on the nature of litigation and the nature of disputants and their goals. We have, well, again, even in our state, Rajasthan, well, the approach of a particular person, say for example in Sri Ganganagar, about a particular matter or a particular cause, would be way out different than an approach of a person down south in Baswada. We know it. Well, there are different approaches. Even towards the same kind of a cause, what a person thinks in Bikaner may not be applying in Bharatpur. That is the vast variety. We in Rajasthan also, we have different approaches. And we understand. That is why what may work today, what may work towards settlement of a dispute in Sirohi, as such may not work in Jaipur or vice versa. But these all are the features, friend. But then pre-litigation mediation, pre-litigation, any kind of ADR mechanism is taking place mostly in core commercial world, and that also in the matters where the parties to the litigation do feel like that going to the litigation is not going to serve the purpose of any one of them, and it is best suited to work out a solution. We remind ourselves, friends, we look at a very interesting feature when we try to understand this ADR system as a whole. We know the government comes out with some kind of amnesty schemes, Sabka Vishwas kind of scheme, right? One-time settlement the banks come out of, come. See, this is also, they were not strictly falling in our section 89, but these are all methodologies ultimately aimed at what? Well, aimed at, well, avoiding the dispute, well, finding some via media, some way out where, well, the losses or where the problems, well, the cause itself, well, goes out. Well, in a classical mediation also, or a classical settlement also, what we say is that a person who is asking for 100 rupees, he is satisfied. Okay, Baba, 90 rupees de do, khatam karo. Okay, that kind of a thing, right? And well, OTS or amnesty scheme or Sabka Vishwas or these kind of schemes, well, they are again an attempt on the part of the government to see to it that, well, the causes are finished, the person pays, and the person also feels like it, that, well, going into litigation, well, troubling himself for years together, well, instead of that, spending time and energy both, time, money and energy rather, the three things, time, money and energy in the litigation, well, I pay off something or a part of it, and well, I buy peace. Well, these approaches, again, mostly in the commercial world, and mostly in where only and only monetary interest is there, they do come up. In those societies, they do come up. But then, when you have a litigation, we are talking of pre-litigation, we have a litigation of this nature where a person is not ready to give up 4 inches of the one particular nondescript old thing of, of his ancestors only for the purpose of, well, standing on a particular value or a system. You litigation, pre-litigation, mediation, conciliation, sir, it falls, he comes and says, sir, मुझे कुछ नहीं चाहिए, आप judgment दे दीजिए. That is what. So the approach would be different, sir. Pre-litigation mediation would take its own, pre-litigation, any kind of ADR will take its own time. With the development of the society, now we are finding, I have seen the pre-litigation scenario, what was available in the state of Karnataka. Well, not necessarily the same was available in the state of Uttar Pradesh. The approaches, the kind of litigation and the standing of the litigant, that makes the difference. So in Rajasthan also it will take shape, but it will take time. With the efforts of all of us, and when particularly the commercial community, when it finds that to be the best way of well, saving time, money, and energy, all, well, it will take shape. It will go on taking shape. It will take time. Yes.
I just want to inform that mediation in the commercial matters, that has already started in commercial court of the state. Presently, those are being taken up at the DLSs now, but now we are in process of establishing mediation center in the commercial courts itself. So this is one part. And secondarily, pre-litigation cases, though through no mediation, but in Lok Adalat, thousands of cases of pre-litigation that have been taken up and disposed of even also, and which was a huge success. That's what.
That's right. It is taking shape. What Brother Justice Patil.
So it will, as your lordship has rightly said, that it will take its own time.
Yeah.
We are in process, and we hope that we will be successful.
No, we just not only hope. I'm absolutely sure we will succeed, but it will take time. That is what I feel like. It will take time. Our society, we have to respect our society and the requirements of our society. So let's go on proceeding on it. Yeah.
Thank you, sir. As it is already 1:15, but we have few more questions, if Lordship permits. So we can continue with the question answer session. Otherwise,
that is only Honorable Chief Justice can say. He is the Chief Justice. I am just an invited guest, nothing more than that.
I may be pardoned, my lord. Your lordship is not an invited guest. Your lordship is here as a member of the family, heading the Rajasthan itself. So we seek your advice. We seek your advice, and I think the questions that are being asked are genuine, and it helps in many regards to clear several doubts. So if your lordship can spare another 10 minutes, I'd be really grateful.
No, we are here, sir. There is means it's a great opportunity for all of us to be together. Sir. And say I'm here till the time. Well, you don't
no, we'll ensure that before my lord feels hungrier than already my lord is. Just 10 more minutes, I think we can close the questions, and then the member secretary will address the Just
may
10
take,
minutes of questioning.
we may take as many questions as required. And yes, please.
Thank you,
Thank
sir.
you, sir.
Next question is coming from Ms. Reshma Khan, ACJM JDA. I would request Ravi Kanji to make her panelist so that she can ask a question.
Good afternoon, Honorable Mr. Justice Dinesh Maheshwari, sir, esteemed honorable judges and guests. Sir, in civil matters, adjudication through ADR processes provided under Section 89, further crystallized by the AFCON judgment. But in criminal matters, adjudication through ADR process, apart from Section 320 CRPC, it is observed that there is a dearth of edifice and guidelines. So my query is, can plea bargaining as enumerated under Chapter 21A be used as an ADR process for adjudication in criminal matters?
Yes.
And why is there a reluctance over the use of this concept in criminal matters?
Madam Reshma, pertinent questions again. Before inviting any brother, just to say on anything on this aspect, I intend to make a few quick comments. As we know, AFCON, again, the Supreme Court reminded us that there are certain categories of cases which may not be suited for ADR mechanisms, and there the matters having criminal offenses involved may not be as such suitable for ADR mechanisms. Even we are evolving on that, and that's why I indicated the decision of Avital, the latest decision of the Supreme Court, which gives us an insight where the Supreme Court has made a distinction to the allegations of serious fraud and the mere allegations, and how do we differentiate in that also. Criminal justice delivery system, well, it has its own reasons, it has its own methods, and it has, well, its own requirements in the society. As we started talking today, well, you remove the magistrate and the big fish will swallow the smaller one. So we need criminal and the society all through head, sorry, always needed criminal justice delivery system. Now, as we know, in most of the cases, it's the state who is the prosecutor. And the state is the prosecutor essentially, as we are taught in our elementary classes, because anything of offense doesn't relate merely to the victim, but broadly, largely to the society as a whole. And that is why state is the prosecutor. That is all said and done. There are, even in the criminal cases, there are minor cases, major cases, there are offenses which were essentially of civil nature, which we have with the later developments and the requirements of society, we have with a classic example is insertion of a chapter in Negotiable Instruments Act, and essentially a species of the civil law, well, where we make the dishonoring of the check bouncing cases, as we know, an offense. And then we have provided for, well, the methodologies to deal with those kind of cases, which are quasi-civil in nature, if I can use that expression, quasi-civil. There are litigations, as it was being indicated by Mr. Gudara also, that, well, there is essentially a matrimonial dispute, a civil dispute, but well, that particular package involves in it domestic violence also, 498A also, 125 CRPC also at L. It happens, it does happen. But then, whether it is Code of Criminal Procedure, whether it is protection from domestic violence, whether it is these are other means criminal offences, the offences which have been provided for in the Indian Penal Code or the special enactments. The concept and the idea is to maintain orderliness in the society. There, that is what the legislature has thought of, not providing for a settlement as such, but yes, it is compounding of the offences. That is what the expression, the different expression is used. Compounding of certain of the offences on certain terms and conditions and the norms. And again, that compounding has to be, well, at the satisfaction of the concerned magistrate. Now you are aware of the liberty available to the prosecution even to withdraw from a particular prosecution and make a request to the magistrate. So we want to withdraw from the prosecution. But then even withdrawal from the prosecution is not a matter of right. Well, it is ultimately your judicial mind that is applied to it. And then you find you may still refuse a particular withdrawal from the prosecution. Compounding of the offense, again, the judicial mind, judicial brain, a process of judicial determination has to go into it. That is what the idea is, broadly speaking. But then there could be minor aspects and there could be quasi-civil aspects where reasonably a settlement may not be counterproductive to the public interest. It is the public interest ultimately that is taken into account even while you are looking at the elements of settlement. Even while you are looking at, even in civil cases also, you find a particular kind of a civil case where there is a proposal for settlement. You deny that particular proposal for settlement if it operates against the public interest. You remind yourself of Order 23, Rule 3. Well, even when there is a particular compromise presented to you, well, you do not as a matter of course put your stamp of approval on it. You have to be satisfied about lawful compromise. It has to be lawful compromise. Even under Order 12, Rule 6, where you grant a decree on admission of the defendant also, you may grant that decree. You ask yourself two questions, whether you are to grant a decree on a decree or a part decree on the basis of the admission or not. The idea, friends, is basically that, well, a judicial brain, a judicial process, a judicial determination is made before a particular cause is taken to a particular destination or a particular finale. In criminal matters, like these kind of quasi-civil matters, yes, like 138 negotiable, particularly when we talk of figures and when we talk of statistics, 138 well hovers over our head of all of us. That is causing a lot of space of all our energies. But then 138 is essentially a species of civil law, in the sense it is inserted also in civil legislation, if we can bifurcate that way, negotiable instruments. It doesn't have direct correlation with public interest or a law and order. If a person has given another person a check that has been dishonored, the person is aggrieved of it, he files 138 with compliance of all that. There is an offense committed, you take cognizance of that also. But the person later on, the other person at fault comes and says, sir, I pay and I finish it. Now here is a question for a judicial officer to ask, that even after putting this matter into the process of the entire prosecution, the evidence, the trial, I mean the process of trial, what are we going to do and what are we going to render ultimately? Ultimately, what you provide for is, punishment because a particular person has done a particular wrong, but at the same time, you compensate by way of, fine with a double the amount of check. The idea is that a person gets payment and this person gets a lesson. Now, this teaching a lesson kind of a thing by way of punishment, a particular person is punished for a particular fault made. Well, that punishment, if it is needed for society's purpose, you provide for it. If it is otherwise not going to serve a society's purpose, by way of these kind of settlements, you do provide for a settlement. And that is why, in that context, a beautiful study is that decision of Dayavati versus Yogesh Kumar by Delhi High Court, delivered in 2017. The Delhi High Court dealt with this very issue as to whether this kind of 138 matters, well, whether they could be taken up for mediation or not. And Delhi High Court provided for a methodology as to how we will deal with it without conflicting with AFCON, without doing anything contrary to what has been provided in AFCON, and without doing anything contrary to what has been provided in our statutes. And that is why, where it has been indicated in that judgment, and that is where the relevance and importance of the mediation rules or the ADR rules by the High Court would go a long way. And the High Court would be making a comprehensive rules with reference to its rule-making power under the Constitution of India. It could be taken care of. That particular judgment is a study. We can definitely draw out a few of the features from that decision and apply it, of course, with whatever modulation. I'm not commenting much about the judgment as such. It is only a High Court's decision, but then it's decision of a different High Court for that matter. But then these aspects could be taken note of, taken care of. The other aspect relating to the plea bargaining, as we find, all of us find, when plea bargaining was inserted in the code of in our system and in the code of criminal procedure, the people were skeptical about the likelihood of its success in Indian scenario, particularly in the scenario of our country. Plea bargaining, even in the United States or even in other countries, is not necessary that it is a success in all states for all time to come, and as if that every particular person or most of the persons who are having an opportunity of plea bargaining, they would be jumping on a plea bargaining, because plea bargaining essentially, again, plea bargaining also has its roots in those kind of litigations and those kind of problems which had been of such nature where a person has done a wrong, but not that kind of a wrong which cannot be remedied by way of some kind of a solution. But then the possibility of even having a conviction and even having a punishment or a sentencing even for till the rising of the court may not be palatable to, may not be acceptable to a particular class of litigant. That is how it happens, and that is why plea bargaining has not taken shape. Well, of course, there are, as the commentators would say, that the tardiness of our system, the delays, maybe the accused take advantage of that. But I'm not commenting on that, because so far as this delay part is concerned, none of us is individually responsible, but all of us are collectively responsible. It is like that. Well, and when I talk of all of us, every role player in the system has to work towards expediting the things. Then only we can deal with. That's why I indicated that 2001 in Gaya Prasad, the Supreme Court would say, the time is running out, we have to do something fast. Otherwise, and the danger indicated is that when we do not get justice in court or law, we resort to extra legal means. That's a serious danger. And it's not unknown that when the people resort to extra legal methodologies, which lead to other lawlessness, which leads to other offenses. So it is for all of us to expedite. when we expedite the things and when the things are likely to happen in this manner, that if today an offense is committed, it's not that by way of certain statutes we provide for that this particular offense decide the matter in 6 months or another offense you decide in 6 months. When this 6 months or 1 year becomes a part of our system, maybe plea bargaining will start playing its role. But before that, thinking that plea bargaining could be a solution, to my mind, as it until now, the experience has been plea bargaining has not served its purpose, and it is less likely to serve its purpose in the present scenario. But it may serve its purpose in a modulated scenario, in a different scenario. That is what we can think of as the students of law as at present. Thank you.
Thank you, sir.
Thank you, sir. Now I think we should sum up this webinar. I would like to request Member Secretary, sir, to render a vote of thanks.
Hon'ble Mr. Justice Dinesh Maheshwari, Judge Supreme Court of India. Hon'ble Mr. Justice Maheshwari Sahab, Chief Justice Rajasthan High Court and Patron Chief, Rajasthan State Legal Services Authority. Hon'ble Mr. Justice Sangeet Lodha Sahab, Administrative Judge, Rajasthan High Court and Executive Chairman, Rajasthan State Legal Services Authority. Hon'ble Mr. Justice Vijay Bishnoi Sahab, Judge, Rajasthan High Court and Judge in Charge Mediation, Rajasthan High Court, Jaipur. Honorable Judges of Rajasthan High Court, respected judicial officers, trainee judicial officers, respected mediators, ladies and gentlemen. I feel honored and privileged to propose vote of thanks on behalf of RSLSA on this ingenious webinar. I am deeply grateful to Hon'ble Mr. Dinesh Maheshwari Sahab for presenting over this webinar. His Lordship's address, as always, was unique for novelty of ideas, manner, and approach. It gave deep insights and unfolded many interesting facts. Once again, I would like to thank His Lordship for sparing his valuable time to enlighten us. Thank you, Lord. I extend a very heartfelt vote of thanks to Honorable Mr. Justice Indrajit Mohanty Sahab. We are greatly encouraged by gracious presence of His Lordship. We are immensely benefited by the inspiring address. Thank you, sir. I take this opportunity to express my sincere thanks to Honorable Mr. Justice Sangeet Lodha Sahab for gracing his occasion. I am thankful for His Lordship's motivation, encouragement, and support. Lordship's presence in this webinar has immensely enhanced its importance. Thank you, Lordship. I also wish to express my gratitude to Honorable Mr. Justice Vijay Bishnoi Sahab. We are extremely grateful to His Lordship for setting the tone of the webinar. Thank you, Lordship. A special thanks to all of Honorable Judges of Rajasthan High Court who blessed us with their valuable time and gracious presence. Thank you. My heartfelt thanks to all judicial officers, trainee judicial officers, and mediators for their active participation. Last but not least, I would be failing in my duty if I do not extend my sincere thanks to officers of RSLSA. Without their cooperation, this webinar would not have been a success. Thank you once again. Thank you very much. Thank you.
Thanks, sir. Thank you.
Namaskar, sir. Namaskar, sir.
Thank you, sir.
Thank you.
Have a good day, sir, and happy Guru Purnima to all of you.
Thank you, sir.
Namaskar, sir.
Thanks.